Regarding the concealing identity, there is no evidence he was trying to in any way disrupt or interfere with an investigation. In fact, all of the evidence shows that he, in fact, was trying to further the investigation by providing his name as soon as he possibly could to law enforcement. Also, by telling them his father was coming, all of this information that he provided to law enforcement freely that shows that he was not in any way trying to conceal his identity.
All right, the standard on these motions is in viewing the evidence that lies most favorable to the state, is there legally sufficient evidence for this matter to go to the trial of fact? I'm going to deny the motion with respect to the second-degree murder and the lesser included. I'm going to find there is legally sufficient evidence for those charges to, that charge or the lesser included to go to the final fact. I'm going to grant the motion of directed verdict with respect to the tampering with evidence and the concealing ID. There's no evidence of that in the eyes of the court, but the murder charge will stay, and that one will go to the trial fact, which is the jury. So, folks, have a safe weekend, and we will see you Monday at be here by 8:45.
Wow. All right.
Wow. Well, I was chatting with Ben, and then somebody pointed out to me that it's still going. Well, they had the motion. They had the motion with this thought, and they granted the motion for the concealing evidence. So that charge is gone. Now we're just to the murder charges. And that, believe it or not, I think that's a really good thing for the defense here. I think he should have granted it with respect to both of them. I understand why he didn't. But it would have been a lot easier to get a garbage conviction on the concealing the evidence stuff. Just have a jury say, yeah, whatever, just to, just to throw the prosecution a bone. But I don't see a jury coming to the conclusion that they've proved this murder beyond a reasonable doubt. Wow. Well, there you have it. A very short stream. I thought I'll let it go and we'll wait till Monday. But I'm like, well, what if it's dispositive? I've got to share the moment with my chat. Whoever's left and comes back at that point. Oh, very, very interesting. Very interesting. So he grants defense motion for the evidence charge, but the murder charges are going to go to the jury. It ought to be interesting. I don't think the defense will have much to put on. They don't have to prove the case, and the case wasn't proved. So they might have some things to offer. I certainly wouldn't call the defendant as a witness. I don't think they will. They seem competent. So I don't know what they will offer for defense, but I would think that would be a short case. If I were representing the defendant here, I'd want to get this to the jury as soon as possible. I might have some stuff lined up for defense that I want to put on real quick, but I wouldn't want to play around with it too much. This looks great for them. Get it to the jury. Not that they're listening to me. Nobody listens to me, but that is my thought. When I think it's going my way, I want it to the jury as soon as possible. I'm not sitting here on collateral issues trying to prove things. I think I'm winning here. I wouldn't want to be sloppy and leave out things that could help, but it would really have to be a big difference maker for me to risk something going wrong. I would be going, if I'm the defense, I would be going into this thinking I've won this case. They've arrested and they haven't proved it. Let's not give them an opportunity to do something, and certainly let's not put the defendant on the stand. So I think that's where we are. All right, sorry, I tapped out early, but for all the world, it looked like it was over. Everybody else thought it was over too. All right, everybody, thanks for coming back out. I appreciate it. You all have a good weekend, and I will see you soon.